Hi, I'm Professor Lord, and for at least the first 2 weeks of the term, most likely the entire term, we'll adopt this format where essentially the theory portion of the course is going to be pre-recorded. And so you can watch these videos before the Wednesday. You can do that during the regular time slot on the Monday if you want to, or you can do that at your leisure. And one of the advantages of that is that, of course, you get to watch the videos multiple times if there's stuff that you don't understand. You get to come back to the videos if you need to. You get to pause me if you're sick of hearing me. And that worked pretty well last year. So I'm open to any feedback you have on that format, but at least last year, for the classes I taught, students felt that having the theory portion being pre-recorded was actually more helpful than having it taught live. So we'll go over in this first video the introduction of the book, which is chapter 1. We'll touch upon just about everything important that we're going to learn about this semester. Obviously, these are things that we'll get back to over the course of the term in a lot more detail, but you have in the introduction all of the important conceptual principles that define administrative law in that we'll get back to over the semester. First thing I should say, there's this thing you've probably heard about called Vavalov, which is a precedent by the Supreme Court of Canada, which was released in 2019. And essentially, the Supreme Court of Canada changed just about everything about administrative law, at least redefined the principles, right? Didn't get rid of the old framework, but substantially revised it. And therefore, the book is relatively good, but it's also the only book that's been revised in time to incorporate Vavalov. You'll notice one of the things with this book is that it doesn't have long excerpts of cases in the way that you'd see in most of your case books. So you might find it helpful, especially for the Vavalov decision, to look it up on the internet, to read it, and to have a look at some of the paragraphs that you see referenced in the footnotes. So you have relatively dense footnotes in that textbook. Most of the cases cited are not all that important. The important ones we'll actually mention later on in the semester. But Vavalov, you might want to have at least a quick read at it and then subsequently go back to the significant paragraphs that are being mentioned in the footnotes, because the format of that textbook is such that that there haven't been long portions of it used in the textbook. So the Supreme Court changed the conceptual framework. That's because the conceptual framework of administrative law is not statutory to start with. Of course, the ability of an administrative decision maker, which we'll see is a very, very broad phrase, is provided for generally by statute. So if you have someone who engages in an administrative action, such as issuing a license, that person has the ability to do that by virtue of the statute, of a law that says, right, this person is hereby granted the authority to issue a license. However, what we're mostly concerned with in administrative law is subsequently how courts are going to review the decision of that decision maker, because, as we'll see, they have an inherent power to basically always do that. So government can say this person is going to make the decision, right, can put all sorts of constraints around that, but you have a constitutional right to go to court, and therefore for a court generally to review that. The conceptual framework that we use to review the decision is not statutory. So there isn't a law, right, it would be called the Administrative Act, that says how the courts are going to review that, that decision by that decision maker, in that example, to issue a license. And therefore, the courts have to essentially make it up, right, based on all the things that they usually use, prior precedents, constitutional principles, and long-standing practices that have been adopted by administrative decision makers. That's why the Supreme Court was able in Vavalov to change the thing right? Because it came up with it in the first place. Prior to Vavalov, there was another precedent called Dunsmuir, which was getting old and unwieldy in some situations, and therefore the court had an opportunity to change the framework and did so. And that's why, as I said, it might be helpful for you to have a look at it both now and periodically over the semester. So administrative law as a concept is very broad because it encompasses a bunch of things that we don't traditionally assume to be decisions, right? We know that courts make decisions in the traditional sense, and they issue this thing called a judgment to let you know what their decision is, right? And we know that that's a decision because the court's empowered to do that, right? Here's a party, decides on what is presented. Basically, everything that the executive branch of government, right, which is a synonym for the people who apply the law, right? So there are people who write laws, they're the legislative branch, and then there are people who apply the laws, they're the executive branch, right? These people make decisions in doing that generally, in applying the laws, right? So they'll decide who gets a license and who doesn't. Or they'll do other more kind of nuanced things, right, in deciding what power they do or don't have. Because the law is going to provide for, right, a sentence that says, right, this is your power, and then you have to interpret that because it doesn't directly lend itself to, right, telling you specifically what you can and cannot do in a specific factual situation, and therefore you have to interpret it. It's also a decision, right, made by an administrative decision maker. So you have to see that as basically every agent of government is generally making decisions, right, that count as administrative decisions. And when they're not decisions that are, right, made by courts, they are still eventually, for reasons that we'll see, reviewable by courts because they remain decisions. Because what happened there is either that bureaucrat made the decision that affects your rights or privileges, right? So he said you don't get a license. Well, you don't have a right to a license, not a constitutional right to a license, but you have a right to a license in some other way. You have a statute that says, right, these are the conditions. If you meet them, we'll give you a license. And then the bureaucrat says you don't meet the conditions. Well, then you can say that decision is illegal. You can say, I did meet the conditions, that person made a mistake. And when you make that claim, you're essentially stating that, right, the administrative decision maker erred in law in a way that affected your rights or privileges, and therefore, right, in a way that potentially engages various constitutional protections that you have. Protections for decisions to be made, right, compliant with the rule of law pursuant to the preamble of the Constitution, or various other, right, procedural guarantees that you have, and therefore you have a right eventually, as we'll see, to go to court and for a court to review the decision of the administrative decision maker to see if it is legit. We'll see legit means a bunch of different things in administrative law. Generally, right, we'll have what we call a deferential approach. In other words, the court is not going to do the thing over because first the government has decided to give that power to administrative decision maker, right? So in that example, right, the license is being issued by an administrative decision maker. Something else the government could do is create a scheme that says if you get into a car accident, you have to go to this specialized car tribunal we just created. And that tribunal is going to adjudicate, right, your pecuniary damages, say, right, which we have in some Canadian provinces. Then what the government's doing is removing that from the purview of the court. Because if you get hit by a car, by default, right, you have an ability to go to court because your rights have been infringed, right? Someone has caused you damages, right, under extra contractual liability. You can claim that in court and get compensation for it. And the default forum is the court. As we'll see, it's the superior court, which has constitutional inherent jurisdiction. In other words, it's the default court in Canada where you go. Then the government's decided that you don't go there. Instead, you go to that tribunal, presumably because the government has all sorts of positive, right, positive aims in doing that, right? We'll see there are a couple main ones, and they're ones that generally define administrative law, right? So first, the government might think that it is good for the decision maker to be specialized, right? So the government might think that the judges aren't actually that competent in automobile accidents, and therefore think that it is better to have people who just do that all day because they've been appointed for that purpose in the car tribunal, and have these people adjudicate your claim because they have specialized expertise. It's a good thing in itself, right? Presumably these people are going to make better decisions than generalist judges. Second, and quite significantly, it's often going to be cheaper. It's going to be more efficient for that decision to be made there, right? Because there won't be all the costs involved in the court system. So we know the court system is notoriously expensive and also slow, right? When the government creates a tribunal, it can try to solve some of these problems, right? It removes these decisions from the court system. Then it can appoint a sufficient number of people to the car tribunal, and therefore, right, you won't have the delays that you traditionally have in the court system. Or the government might say, your hearing at the car tribunal is going to be made pursuant to laxer procedural standards than you'd have in a court, right? One of the things that our courts are really good at is protecting your constitutional rights, right? You have a lot of rights in court. You have a right to contest every single thing, right? You have the right to say it wasn't filed properly. Then you have a right to preliminarily, right, examine witnesses that are eventually going to be heard. Then you have the right to ask for documents, and then you go to the trial, and then you have the right to have your witnesses heard, then you have the right to cross-examine the other witnesses, then you have the right to show your evidence, you have the right to respond to the other party's evidence, and then you have the right to plead all the law that you want, to tell the judge how you want that decision to be made, and then subsequently, if you're not happy with that, you get to go to the Court of Appeal, generally as of right, right? So you have a right to go somewhere else and say, this whole thing was done wrong and therefore I want it canceled. That's a lot of procedural guarantees, right? And then subsequently you can even go to the Supreme Court, but you don't have a right to do that, right? You have to ask for what we call leave to go to the Supreme Court, which is permission. All of that is really good at protecting your rights. To the extent that you can afford to do all of that, it's really good because you get the truth, right? You get to really ask the tough questions, you get to get the documents, and you get to do your evidence in a way that's adversarial and gets us to the truth. What it's not good at is being quick and efficient, right? And oftentimes, if we assume that this thing costs, say, $40,000 for a relatively simple trial, then what that's going to do is that if your dispute is worth less than, say, $40,000, you just won't go there, right? Because it's not worth it. So this thing does a really good job at protecting your rights procedurally, but that has a cost in the real world, namely that you pay your lawyer to be there the whole time. And as a result, right, your rights aren't really protected. In other words, right, to grossly oversimplify things, if someone does something bad for under 40 grand, it's free because you won't sue. Because it's not going to be worth it for you to sue. And it's not something that the government wants, right? Because then these guarantees become meaningless for that specific segment of disputes that are just not worth adjudicating. So that's one of the reasons why the government might say this is going to be the car tribunal. And at the car tribunal, we mainly make decisions that are lower value, and therefore we'll make these decisions pursuant to a different process. A process whereby, right, we have fewer procedural guarantees. So you might not have the right to have as many witnesses heard. You might not even have the right to express yourself in speaking. It might be in writing. You might not have the right to an appeal. in a traditional sense, right? The government might limit the ways in which that decision can be reviewed. Various other things that ultimately try to make the thing cheaper and finally more efficient, right? Or innovative. That's two ways to put it. Essentially, you have an ability on the part of that body that's given decision-making authority to be more innovative, right? To do things differently, and that's generally good because it can help us fix the mainstream court system, which has all these issues that we discussed. So administrative law is, as you mentioned, part of public law in the sense that it's the law that unites the government and people. Private law unites people and people, right? So if you get hit by someone, right, it's a criminal act, but it's also a tort, right? Then you can sue that person, and that's private because you are yourself as a private individual suing a private individual. It could also be a company, would still count as a private person, right? Private entity. When it's your relationship with the government, it's what we call public law. It's also what constitutional law is, right? Because constitutional law governs what the government gets to do or not do with certain rights that we consider to be constitutionally protected. So it limits generally because the Constitution, the charter only applies to public action, right? It doesn't apply to the tort, for instance. Because it only applies in that context, provides limits most often to the laws that can be passed by the government. Administrative law is public law in the sense that it governs the same relationship. So if you have a bureaucrat issuing you a license or not issuing you a license, right, that decision is a decision that is between you and a public entity. That person represents the state. We'll see there are various other relationships with constitutional law. Namely, as I said, first that we have various principles or protections that come out of constitutional law, right, that protect, say, your procedural rights. And second, sometimes administrative decision makers are going to be called upon to apply the Constitution, generally the Charter. As a result of that, of these advantages, right, we have an approach that is what we call deferential. In other words, the court is not going to get involved unduly. Why is that? Well, as we'll see, and as I said earlier, you generally have a right to go to an actual court if you're not happy, by virtue of your constitutional right and by virtue of the court's inherent jurisdiction. That can defeat the whole purpose of what we just said. If the government creates this car tribunal, right, which is good for all these reasons, but then you have a right, by virtue of the Constitution, to seek, quote unquote, judicial review, quote unquote, of that decision. In other words, you have a right to ultimately get to court as you otherwise would have in the first place if that tribunal did not exist. If the court is going to have the power to do the thing over, it would defeat the purpose of the administrative system, right? Because then you would have all of the costs and the delays, among other things, that you have inherent to the court system being imported back into that system. For that reason, as we see with other things like arbitration, for instance, the court is going to respect the intent of the parties, in that case the intent of the legislator, to pass a law that says we want to have a car tribunal for these reasons. And the ways in which the courts respect that decision is by not unduly intervening in reviewing these decisions. So when you ultimately get to court, what the court gets to do is limited, and that's because the court, right, wants to defer to the administrative decision maker. In other words, be generous or non-interventionist in that process. And all of that is because the court respects these aims that are generally sought to be served by the government when it makes a decision to remove something from the purview of the courts, which is not always the case. Some things are administrative by default, right? But the decision of the government to make that an administrative decision in one way or the other. Generally, what that means is that the courts are going to be first very concerned with the competence of the decision maker, quote unquote, and that is the legal authority that they have to make a decision. Why is that? Well, you see, it gets perverse if the court doesn't have the ability to do that. Because then if the court says, this is something that's been added to administrative law by the government, therefore we will not intervene. We just won't look at it, for instance. That wouldn't be constitutional, right? But the government can limit it to some extent, as we'll see, not fully. But whatever limit we have is within that continuum. So whatever limit we have, essentially the court, right, restricts its ability to review the decision, restricts how much it's going to look at, say, the factual record or the way in which the decision was made. Then what that can do is that the government can seek to avoid judicial review of an illegal decision. So the government might tell the bureaucrat, make a decision that you have absolutely no ability to make, right? Unrelated to, say, a driver's license. And then the court would not be able to review that decision because the rule would be court doesn't look at it. That wouldn't be fair. So that's one thing that the courts are going to be very concerned with. The courts are going to be very concerned with whether the person who made the decision, for instance, to issue the license, and again, these are all things we'll get back to over the semester, the person who has the authority to issue the license, right, whether they actually have the legal authority to issue the license. The court's going to be very concerned with checking that because it's a preliminary issue in some way, and because, right, otherwise it would be a way for the government, right, which otherwise has to answer to the courts by virtue of the Constitution, to delegate that decision-making power to some other entity that is not a court and therefore avoid that, right, constitutional check and balance. Generally, as we'll see, there's a Latin phrase that says, which I won't repeat here, that essentially powers can only be delegated once. So, the power, for instance, to issue a license, right? By default, that is going to be a power that is of Parliament in some way, right? That power can be delegated to the bureaucrat I mentioned. There's a rule that says that power cannot subsequently be delegated. So the government has the ability to delegate a power that it has, but just once. The person who gets delegated that power does not have the power to do the same thing. Back to deference, generally what that means is that we consider, and these are things we'll look at in a lot more detail, you'll get very annoyed with it, that we look at the reasonability of the decisions. One of the reasons you'll get annoyed with that is that it doesn't really mean anything, right? So generally, the applicable standard under Vavalov for most decisions being reviewed by courts is going to be whether or not the decision is reasonable. That is somewhat complicated because it doesn't have a hidden three-step test that you can look at as for, say, Section 7 of the Charter. It is in itself contextual, inherently contextual, and therefore vague. Generally what it means is that we adopt a deferential approach, that the court is going to try not to get involved too much in the decision being made by the administrative decision maker. Therefore, the court is going to be generous in what it allows the administrative decision maker to do. For instance, the court might think that the decision that was reached is not the best decision. So, administrative decision maker interprets a statute, and the court says, that is clearly not the best way to interpret that statute. Court does not get to intervene in that situation. Court might think it is, right, an incorrect decision in some situations, but still one that can reasonably be made in light of the factual record. And again, the court is not going to intervene. It's because the court has deferential approach. Under reasonability, essentially, right, we don't really assess the reasonability of the decision substantively. We assess whether that decision is part of the reasonable range of outcomes that could have been reached by the decision maker. And oftentimes that means that we do not look at the substance of the decision. So that's kind of hard to understand the first time you hear about it, but essentially it means that we look at mostly the way in which the decision was reached. For instance, a decision that has 30 pages is more likely to be reasonable, because then you can tell how the person made that decision. Even if it's a bad one, even if it's not the best one, you can tell why they made that decision, and therefore it's likely to be reasonable in light of the record. You can see how the decision maker took stuff that are inputs, right, looked at the law and the facts and whatever they had before them, combined those, and then reached, right, eventually a decision, and you see what the Supreme Court calls a chain of analysis. You can see how that decision was reached, and therefore it's likely to be reasonable. What you see there is that the court, in doing that, avoids actually doing what the administrative decision maker did. In fact, the court technically is prohibited from doing that. So the court cannot open the factual record, which you'll have upon judicial review. So you'll have the 2,000 pages of evidence that were used by the administrative decision maker. The court doesn't even get to look at it to say, right, see how it would have decided that case. The court looks at not the substance of the decision, but looks at whether, right, the chain of analysis in that example is reasonable. And to the extent that it is, the court stops there. If it's not, then the court might need to look at the record. And then the record might tell you, right, now you understand the decision because it helps you interpret it, for instance, and that's allowed in some situations. But to the extent that the decision itself allows you to see how it was made and is therefore reasonable, right, then the court doesn't look at the actual substance of the case that was decided by the administrative decision maker. This is generally what we mean by reasonability, which is a deferential approach to the review of an administrative decision. There's a converse standard, as we'll see, which we call correctness, where the court does the opposite. For some things that are really important, the court is going to get to do it over. The court is going to get to look at whether or not it would have made the same decision and have essentially the opposite approach, a non-deferential approach, and therefore not allow for mistakes to be made because the issue is very serious. Again, these are all things that we'll look at in a lot more detail. The default remedy under administrative law, interestingly, is not for the court to substitute its decision for the decision of the administrative decision maker. For example, if you go to an actual court, right, and you'll see there's similarities there, right? So an actual court, for instance, is going to make a decision, right, based on the factual record. So it's going to have, right, a bunch of documents in front of it, then it's going to have witnesses, it's going to assess the credibility of the witnesses, and then going to reach decision. If someone goes on appeal, one of the reasons why the Court of Appeal does not get to do that, to substitute its decision, does not get to redo the thing, is because it does not have the same privileged access to the factual record. It doesn't have the witnesses before it, right? Doesn't have, right, the submissions of the parties at length, because, say, the trial wasn't recorded, right? And therefore, there are certain things that might not appear to be logical within the decision that might very well be if you have the context of the trial. And therefore, the Court of Appeal is going to have a standard for factual issues or issues of mixed fact and law that is more deferential, where there has to be a big error, right? Palpable or overriding error for it to substitute its decision. So again, an approach where, right, the review is deferential for reasons that are, right, part of the architecture of the system, and therefore, right, the court limits its ability to review the decision. So you have that in administrative law in a very similar way. However, generally within the usual court system, what the court would do is generally correct the decision. That's not what we have in administrative law. What we have is the court is going to do what we call quash a decision, cancel it in other words, and then send it back to the decision maker. And that sounds very inefficient, right? Because then you have what we call in some situations a merry-go-round, where, right, the administrative decision maker makes a bad decision, then court quashes it, returns it, and then they make another bad decision, and then the thing goes on and on and on, right? But generally, the reasons why that's the default remedy is because of the underlying purposes of administrative law. It's because it would not respect the specialized expertise of the tribunal for the court to substitute its decision as if it had the same expertise. And so the court is going to send it back. Generally, it's going to be another decision maker, another person within that tribunal making that decision. But still, that's one of the ways in which the court respects these underlying principles. And generally, right, it's also going to protect the ability of that tribunal to make decisions in a way that is, right, somewhat different from the court system. So there's a discussion of the rule of law there, not that significant, but generally you have to have a legal basis upon which to make a decision, right? And therefore, it's one of the reasons why the court's able to review whether or not the administrative decision maker made the decision that is compliant with, right, the legal principles that empower that administrative decision maker to make the decision in the first place. Then you have a very long discussion around page 4 of essentially the jurisdictional boundaries between decision makers. Sounds very arcane, right? Essentially issues of whether or not the decision maker has the legal power to make that decision. Prior to Vavalov, in other words, forget everything you have on pages 4 and 5, right? Prior to Vavalov, that was a threshold issue. So that was something you looked at separately, which kind of makes sense, right? You look at whether or not they have the power to make the decision before you look at the decision itself. Under Vavalov, that is not the case. It is all part of the same review, as we'll see later on in the term, and therefore falls under, right, reasonableness review. And if it's an issue that strictly has to do with the jurisdiction of the court, it might be subject to correctness review. But it still falls within either of those standards, which we also use to review the decision itself. It's no longer a threshold issue, in other words, something that's assessed separately. As we said, you have certain procedural rights, and these are by virtue of the Constitution. So you have certain constitutional protections, right, which apply again because the Charter and the Constitution applies to public action, which applies to your relationship with the state and therefore to administrative law. So if an administrative decision maker makes a decision, right, for instance, they take a bribe, right, they're biased, these are things that you're protected for or against under the Constitution. And therefore, it doesn't matter whether or not the government decided to give that decision maker the power to make that decision. It doesn't matter that the government said this is no longer subject to the court's jurisdiction because it's constitutional. Also doesn't matter that it's not provided for in the statute, for instance, because it's a constitutional protection that applies by default and regardless of what the government provides for. And that's why you have certain procedural protections. Of course, they will be somewhat different, right, in the sense that the court, to some extent, in interpreting the Constitution, is going to respect these things there, right? It's going to respect the fact, as I said, that it's not always good to have very strong procedural protections because it's expensive, and therefore the court is going to, right, limit the extent of these procedural protections. For instance, as we said, right, you might not have the right to be heard in speaking, you might not have the right to submit as much evidence, might not have a right to cross-examine people, various things, might not have a right to a lawyer, right? All sorts of things that might otherwise be constitutionally protected. Nonetheless, you have a minimum of procedural guarantees because these rights are constitutional in nature and cannot be abrogated, although they can be limited. You have a continuum that we'll again look at in more detail that focuses on the impact of the decision on the person, right? So the procedural protections are going to fall somewhere along a continuum, even within administrative decisions. And that, under Vavalov, depends on, and other precedents, depends on the importance of that decision to the person. It's actually very intuitive, right? If the government in some way is going to take away very important rights from you, you're going to want the government to do that in a way that's more fair, that gives you a right to be heard, a right to contradict the case that's being made against you. We see that in constitutional law more generally. For instance, when the government puts you in a cage under the criminal law, that's something that takes away a lot of rights from you, right? Under Section 7, basically your right to life, to liberty, sorts of things, right? And therefore, we have more stringent protections. The government's going to have to give you a free lawyer, even though it doesn't have to do that in other situations under laws that are not criminal, right? Same thing under administrative law. How much we protect your ability to have your case heard is going to depend on how significant the rights that we are trying to take away from you are, and that goes on the spectrum that from what's called natural justice, which is the more stringent protection, to a standard of quote-unquote fairness. Again, these all being things we'll get back to later on in the term. You have a bunch of contextual factors at page 10, which we won't get into in that much detail. Contextual factors meaning they are things that you look at, they are not a test and therefore are not cumulative. So if the Supreme Court says you've got to have 4 things under the Constitution, right, for instance, that is cumulative. That's not what contextual factors are. Contextual factors are things that you look at where you don't have to look at all of them, you don't have to meet all of them, they're just things that are helpful in your analysis of the decision you're trying to make, right, as to whether or not something respects the obligation of procedural fairness in that example. For the same reason, you could look at things that are not listed there because, again, they're factors that allow you to assess the context and therefore, right, in my example, how stringent the protections are going to be. Something we'll look at later on is what we call privative clauses. Essentially, the government within that administrative system is going to decide whether or not you get an appeal. As I said, because you have a right to eventually go to court, the government doesn't get to decide that. The government doesn't get to tell you you do not get eventual judicial review of an administrative decision by a court because that is something that is constitutionally protected. However, the government within the administrative system can say you don't have a right to an appeal. So in my earlier example, you can have the car tribunal. The government might say these are very significant decisions because people are injured, and therefore we'll also have the appeal car tribunal that is going to have various powers to ensure that the car tribunal got it right. If the government does not create a right of appeal, it's what we call a privative clause. And that is suggestive of the government's intent to provide for deference or not within that framework we looked at. So if the government doesn't give you a right of appeal, that's because the government wants that initial decision maker to have broader discretion, right? In other words, it doesn't put someone there to check their work because they're confident they got it right. That's deference. Therefore, the court is going to take that into account. Not again in not reviewing the decision at all because you're allowed to have that by virtue of the Constitution, but in deciding how much it's going to review that decision under that spectrum, as we said, from correctness to reasonableness. I said earlier that you have a right to go to court by virtue of the Constitution. that Section 96 of the Constitution, not the Charter, the Constitution, right, essentially says that. Says that you have a right to go to court when you've been injured by, right, a private party or the government. And the Constitution provides that by default that is going to be the superior court. And so you have a bunch of courts in Canada. But if you don't know where to go, you go to the superior court. By default, it is a constitutional court, because it's created by the Constitution, of inherent jurisdiction, of default jurisdiction, in other words, right? Where you go if you don't know where to go, you've got to have somewhere to go because the Constitution says that, and the place you go is the Superior Court. Even though it has provincial branches, right, even though you have the Ontario Superior Court, it's still the same court, right? It's still the same court of constitutional jurisdiction, and, right, that's also why you have judicial review of an administrative decision. Because again, you have a right to go to court. So the government can say, well, give that to the Car Tribunal, and therefore the government can limit the jurisdiction of the Superior Court in saying that that jurisdiction is going to be, right, moved to the Car Tribunal, at least at first instance. What that does is that, right, government says you have to go to the Car Tribunal, you lose your right to go directly to the Superior Court and say, I got into a car accident. Therefore, the government has limited the jurisdiction of the court in that example, but the government doesn't get to do that entirely because it's constitutionally protected. And so eventually, once you go through the Car Tribunal and or the Car Appeal Tribunal, which the government created, at the end of the day, you have a right for that administrative decision, which was made oftentimes by someone who is not a judge, right? Might be an administrative judge or might be a bureaucrat. You have an eventual right for that decision to be reviewed by an actual judge by virtue of the Constitution, and it also arises by virtue of the inherent jurisdiction of the Superior Court under Section 96 of the Constitution. Page 15, you have examples of situations that fall under either reasonableness or correctness review. These are all things that we'll get back to in greater detail. But reasonableness generally applies to everything where it's everything that is not otherwise subtracted from reasonableness review. So issues of what we call mixed fact and law, issues of interpretation of the statute where that is within the specialized expertise of the tribunal, and issues of law and fact, right? Mixed law and fact. These are all things that are subject to reasonableness review. Reasonableness review is the default standard. Correctness applies for limited things. First, where a statutory right of appeal exists in the statute. Again, because the government indirectly told us it doesn't want us to be deferential, so we won't be. Second, constitutional issues. That makes sense, right? Third, an issue of general law that is of both central importance to the legal system as a whole and outside the adjudicator's specialized area of expertise for the reason I mentioned earlier. Of course, that's broad, right? Any smart lawyer is going to plead that everything is an issue of central importance to the legal system as a whole. But to the extent that, right, it's true, the administrative decision maker gets the ability to influence something that really they shouldn't have the ability to influence, right? They get to make decisions on car accidents, not decisions that fundamentally drive, right, how the Constitution is interpreted, right, or how, right, important legal principles outside the Constitution are interpreted, and therefore we limit that. Jurisdictional issues, as I said earlier, to the extent that they're actual jurisdictional issues. Actual issues as to whether or not that person or entity had the legal entitlement to make that decision. That is a traditional jurisdictional issue. That is going to fall under correctness review, so less deferential standard.